Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with Supreme Court this week. The Supreme Court has refused to entertain a petition seeking implementation of the 2012 recommendations of the Election Commission regarding the cooling off period to prevent public servants from contesting polls immediately after retirement or resignation. The petition, filed by G.V. Harsha Kumar, a former parliamentarian, had sought directions to the EC and the Centre to implement the 2012 recommendations of the poll panel and the July 2004 report of the Committee on Civil Service Reforms to prevent government servants from contesting elections to the legislature, parliament or state assembly on a political party ticket immediately after retirement or resignation from service by imposing a cooling off period. It had also sought a direction from the Centre to grant one pension to the bureaucrats who have served as members of Assembly and Parliament. The Supreme Court has held that the time spent diligently pursuing a matter before the wrong forum is bound to be excluded while computing the limitation period. The division bench of Justice Sanjay Karol and Justice Aravinda Kumar therefore allowed an appeal and restored the execution application before the Munsif Court to be considered afresh. The court referred to MS Consolidated Engineering Enterprises versus the Principal Secretary, Irrigation Department and others for principles pertaining to applicability of Section 14, wherein it was particularly observed that the provisions must be interpreted to further the cause of justice rather than aborting the proceedings, and that time taken diligently pursuing a remedy in a wrong court should be excluded. The Supreme Court has answered the question as to what happens when a matter pertaining to the check bounce is eventually dealt with by the courts of civil as well as criminal jurisdictions. The division bench of Justice Sanjay Karol and Justice Aravinda Kumar held that since the civil court had declared that the check was issued for security purpose, the proceedings for a check returned unrealized due to closure of the account could not sustain in law. The court expressed concern over the manner in which the matter reached the court on how a civil as well as criminal course could be adopted by the parties pertaining to the very same issue and transaction. The court referred to K.G. Parmeshankar versus Inspector of Police and others, wherein it was held that no straitjacket formula could be laid and that conflicting decisions of civil and criminal courts were not a relevant consideration except for the limited purpose of sentence or damage. The Supreme Court has imposed a cost of ₹5 lakhs upon Himachal Pradesh Housing and Urban Development Authority for proceeding with the tender process, which was already declared to be having illegalities and irregularities and sought to be cancelled by a committee. The division bench of Justice Bella M. Trivedi and Justice Pankaj Mittal further clarified regarding the non-binding value of letter of intent denying any legal relationship between the party issuing the one in whose favor such LOI is issued. The court reiterated that LOI was a mere expression of intention to enter into a contract which does not create any right for a party in whose favor of the same was issued. Now let's have an overview of High Courts. In a significant ruling, the Madras High Court has held that hostels being used for residential purposes will not attract goods and services tax. The ruling by Justice Krishnan Ramasamy has quashed a decision by the Tamil Nadu State Appellate Authority for advance ruling that had said that this would attract GST at the rate of 18%. In its ruling, the court held that GST is not leviable on hostels as the end use under the purview of the residential dwelling for the use of residents. Tax experts noted that renting for residential reasons is exempt under GST, but there remained ambiguity on the rent and hence exemption was not allowed. The ruling emphasized that exemption would be available and such exemptions should be seen from the lens of service recipient vis-a-vis service providers. The division judge bench of Jharkhand High Court has held that in a case of circumstantial evidence, the examination of the investigating officer becomes very important. More so, the evidence which has been collected by the former investigating officer has not been proved by the second investigating officer. As such, the same becomes fatal to the prosecution case. The court, in this view, set aside the murder conviction against the accused. The single-judge bench of the Andhra Pradesh High Court has held that when an employee is guilty of misappropriation of amount, the quantum of amount is immaterial. The loss of confidence of the employer on the employee would have to be dealt appropriately by imposing appropriate punishment. It was furthermore observed that the law is very clear that the amount of money that is misappropriated by an employee does not matter in cases where the employee is guilty of misappropriation of the amount. The Patna High Court, while setting aside an order of the conviction under Section 498A, held that a husband calling his wife Bhoot or Pisach itself does not constitute an act of cruelty, and observed that in matrimonial relations, especially in failed matrimonial relations, there are incidents where both the husband and wife abuse each other by using filthy language. However, all such accusations do not come under the will of cruelty. The Allahabad High Court has held that Section 195(1)(b) CrPC does not bar registration of FIR in a case where alleged forgery has been committed in the document outside the court and thereafter it has been filed in judicial proceedings in a case pending in a court. The court clarified that it merely bars the magistrate shall not take cognizance of an offence regarding the forged document unless the court in which forgery has been committed filed a complaint case in accordance with the provisions of Section 340 CrPC. Moving on to international news this week. 8 judges of the Islamabad High Court, including Chief Justice Amir Farooq, have received threatening letters filled with suspicious substance amidst allegations of interference by the Pakistan's powerful intelligence agencies in judicial matters. The development, which raised concerns about the security of the judiciary, come days after 6 judges of the ICH addressed a letter to the Supreme Court Chief Justice Qazi Faiz Issa complaining of the meddling in the judicial affairs by the intelligence agencies of the country. A pensioner named Anne Siago was threatened with a fine of £100 after a neighbour complained that pigeons and seagulls were a plague. The Municipal Council of Fidel informed Anne that she is in danger of committing a criminal offence after the retired music teacher, her son and 2 neighbours were accused of antisocial behaviour. The Municipal Council insists that they acted correctly by sending a warning letter and said that they could take further steps. In the end, we have miscellaneous news. The Supreme Court has agreed to consider a challenge to the constitutional validity of the reinstatement of 6 months period limitation to file a motor accident compensation claim under the Motor Vehicles Act. A division judge bench of Justice Sudhanshu Dhulia and Justice Prasanna Balachandra Varale issued a notice in a writ petition filed against the 2019 amendment to the Motor Vehicles Act, bringing back the old provisions of Section 166(3), mandating the filing of a claim petitions before the tribunal within 6 months from the date of the accident. The provision under challenge took effect from April 1, 2022 and was originally removed by way of amendment of 1994, providing road accident victims unlimited time to file suit. The 2019 amendment brought it back and is now under challenge on the grounds of curtailing rights of victims by placing a strict time limitation. The petitioner has argued that the provision is not in tune with the legislative intent of the statute designed to primarily provide relief to the victims. Expressing serious concerns over the implementation of the Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam, the Vice Chairman, Secretary and the 2 members of the Bar Council of Delhi, in a letter to the Home Minister Amit Shah, have urged him to not implement the same. The 3 laws are set to replace the existing Indian Penal Code, Code of Criminal Procedure and the Indian Evidence Act, respectively, from July 1st. In the letter to Mr. Shah, the BCD office bearers have objected to the extension of the police remand period from 15 days to 60 to 90 days under the new laws. The letter also pointed out that handcuffing the accused had been held to be inhumane, unreasonable and against the constitution in the 1980 case of Sunil Batra and Prem Shankar Shukla. The members also maintained that community service as a punishment is arbitrary, unregulated and unspecific apart from being impracticable. The office bearers noted that the mix of Hindi and English, deletion or change in the provisions related to some offences had over the years become deeply embedded in the justice system, and judges, lawyers, police officials and even the general public were required to study the new laws afresh. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.